In the last video, I had dealt with the jurisdiction, its various angles, and thereafter it is now necessary to tell what is the jurisdictional fact and what are the jurisdictional errors. A jurisdictional fact is a fact which must exist before a court assumes authority to decide. And in fact, these are the facts which are derived from the law or provisions of law. And authority, when the court assumes to decide, it is said that the court has jurisdiction. If the court has no jurisdiction, then the matter which is filed or the pleading which have been filed are not maintainable in legal terminology. They are said that they are not maintainable because the court had no authority to decide, means court has no jurisdiction to decide. So therefore a jurisdictional fact is one on the existence of which or on the non-existence of which depends of the jurisdiction of a court. It may be the territorial jurisdiction, it may be the pecuniary jurisdiction, it may be the subject matter jurisdiction. So it is in fact, this is upon which an administrative agency or powers depend, and in jurisdictional fact, that does not exist, then the court will not have any authority to decide. For example, if law says that Section 6 of a Specific Relief Act says that if any person without his consent dispossessed from the property in possession, or any person through whom the possession is taken by without due course of law, then the person who was dispossessed or any person whom he claims the possession can file a suit. So here is the jurisdictional fact is that if a person is dispossessed, one thing, and he has been dispossessed without due course of law, then third is that it was without his consent. So these are the jurisdictional facts which the Section 6 says. These are the jurisdictional, unless these jurisdictional facts, because these are the provisions of law under Section 6 of a Specific Relief Act, then if they do not exist, the court will not have any authority to decide. For this purpose, it is very much necessary to see what are the provisions of law which will give you the jurisdictional facts. This is the simplest example, and this is most common in the district court. When the persons are dispossessed, then they file the suit for recovery of the possession from the immovable property. So this is one of the example. Further, in subsection 2 of Section 6, it is said that no suit can be brought by any person who has been dispossessed if 6 months have passed out, or a suit for recovery of possession cannot be brought against the government. So these two facts are barring the jurisdiction of the court. These are also the jurisdictional facts. If these two facts are also exist, then the suit will not lie. That is to say, that suit will not be maintainable by a person who has been dispossessed without his consent or without due course of law. Meaning thereby the jurisdictional facts have to be derived from the provisions of law. This is an important aspect in the matter of jurisdiction. Subsection 3 of Section 6 says that if suit is filed by person dispossessed and he lost the suit, that is to say that his suit is dismissed, then appeal shall not lie against such dismissal order. This is another jurisdictional facts which Section 6 of the Special Relief Act says. So it clearly says that no appeal shall lie from any order or decree passed in any suit instituted under this section, and nor shall any review, even the review has been barred, review in any such order or decree be allowed. So this is another jurisdictional fact. This is the best example on the person on the jurisdictional facts, because first it says a person who has been dispossessed without his consent from the immovable property may recover the possession within 6 months, but he shall not recover the possession in against the government. So these are the jurisdictional facts. Another position is that if the suit is dismissed, then appeal shall not be lying, or a review will also not be lying. That is to say, these are the jurisdictional facts in both sides. If you are against this, you are against the suit, that is you are defendant, then you can take subsection 2 or subsection 3 of the section 6 specifically fact. So these are the jurisdictional facts. Unless they exist, the court shall not have authority to decide the suit. Further, subsection 4 also provides that if suppose the suit is dismissed against a person who has dispossessed another from his property, it does not mean that he has no remedy. The subsection 4 say, if he is the owner, he can independently file suit for recovery of possession. Hardly matters that he has been the case suit against him has been dismissed, or he can set up his title in another suit, which means the remedy has not been barred, even if the res judicata may be there, but the res judicata will not apply in case that ownership title is with the person as a defendant in the dismissed suit. So this is another aspect of the suit. But another important aspect is that appeal is not allowed, review is also not allowed against decree or judgment. Then is there any remedy? What can be the remedy for a person whose the suit has been dismissed? Then the only remedy is to see by the higher court or the appellate court or the another court which can revise the order or judgment or decree. So that is the section 115 of Code of Civil Procedure, which says about the jurisdictional errors. Now the jurisdictional fact which I have been telling to you is that the fact which exists, the existence of which of that jurisdictional fact is the sine qua non, in legal terms the mandatory condition. Sine qua non means the mandatory condition for exercising the power to decide or authority to decide. If the jurisdictional fact exists, the authority can proceed with the case and decide the matter in appropriate manner. So this is an important aspect which is the primarily to be understood by the aspirants and AOR examinee. And another thing is, if the court has proceeded with to decide the case or the suit, then there may be two situations. The court may not be having jurisdiction, yet it has started deciding, or it has itself conferred upon itself the jurisdiction and decided. The two situations are there. One where the court has wrongly taken the jurisdiction upon it. The result would be whatever. If that result is that the court decides whatever way and it is not challenged in the higher court or the higher or before the higher authority, then it will remain good as it could be. So it is very much necessary for an advocate who appear or who contest the suit or any case where he can show to the court that the court has no jurisdiction at the very first step. Otherwise it will remain good and it will hold good. Another thing is that the court may exercise its jurisdiction vested in it, or court has wrongly exercised the jurisdiction vested in it by the provisions of law, or if it has no jurisdiction, then it has. So these are three types of the errors which have been given in section 115 of Code of Civil Procedure, and these are known as the revisional or the jurisdictional errors. And these three conditions are there. In this case, particularly when section 6 of a Specific Relief Act, if you see the question number 1 of 2024 AOR exam, you will find that both sections have been given after the question is put, and there 115 is there. You can see three conditions, they are the jurisdictional errors. And jurisdictional errors is the only situation where the court can reach to a good decision after it has seen, because appeal was not allowed, review was not allowed as per section 6 of the Specific Relief. Therefore, what remains, that the jurisdictional has to be seen in such cases where appeal and review are not allowed by the provisions of law.